Hail there, legal warriors. 5 shocking myths about DUIs in Washington state. That's what I'm going to cover in this video. I hope you never need a DUI lawyer, but this is good information to have. So stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington state for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people will get the help they need. Now I'm just going to jump right into it. We probably all have an idea what a DUI is, driving a motor vehicle while under the influence of alcohol. And there's what's called a per se limit in Washington state, 0.08. And a lot of people might think that if we blow over 0.08, there's no hope. There's no way that we're going to avoid being convicted of a DUI. So that is myth number one, that you're always guilty if you blow higher than the legal limit here in Washington state. Now, why is that a myth? Well, you might guess that there can be problems with breath test machines, right? We used to use the BAC verifier data master in the state, and over the last several years, we moved to the Draeger. And the Draeger is a very complicated machine. It is subject to challenge in lots of different ways. It's supposed to be more accurate, but us defense attorneys say otherwise. So even if you blow over a 0.08, there could be something wrong with the machine, which makes that inaccurate. Secondly, the officer also has to do things a certain way. Just because the machine says 0.08, it doesn't mean the police officer followed the rules by the state toxicologist. What's one important rule? They have to do a mouth check. They have to see if there's something in your mouth for 15 minutes prior to you taking that breath test at the station. If they don't check your mouth or don't ask if there's something in your mouth, either counts, then the breath test will get suppressed. Additionally, they have to maintain constant observation over you for the 15 minutes prior to the breath test after the mouth check. So if they leave your presence, if they turn their back for a long period of time, we may have an argument that the state toxicology rules were not followed. The state wrote the rules, the state needs to follow the rules, and then perhaps we can get your breath test suppressed. That is why attorneys will oftentimes request, at least ones with bigger firms like mine, will request BAC room videos. Most breath test rooms will have a video of the room without any audio, where we can see what happened. But that evidence often wastes, often gets recycled, and the prosecutor will never, ever get it. I've never seen the state ask for breath test room video before because it can only hurt their case and can't help their case. A little known secret is on the police reports where the police officers mark that they did everything right, the boxes they need to mark for their testimony are marked in bright yellow, so they can't miss it, right? So every time, we solved the problem, the state did, we're going to make sure the officer testifies correctly no matter what by making neon yellow the spots they need to mark. Does that seem fair? I don't think so, but that's the way it is. So that's myth number one. Myth number two is you automatically lose your driver's license after a DUI arrest. And that simply is not the case. Now, for an adult, 21 years or older, we're supposed to lose our license if we blow 0.08 or higher at the station, or if we refuse a breath or blood test after receiving implied consent warnings from the police officer. And what the actual implied consent warnings say, it says, hey, you're going to be asked for a test of breath or a test of blood, and if you refuse, you're going to lose your license. Well, so many people think that if they fail a breath test or if they're arrested for a DUI, they automatically lose their license. That is not the case. You have a chance to fight about it. If you have blown over 08 or refused, you are supposed to get a notice in the mail saying you're going to be suspended 30 days after the event. But you're also supposed to get a form to request a driver's hearing, okay? Right now in 2023, the driver's hearing costs $375. You can request it online through your licensing express account, dol.wa.gov, or you could send in the request in writing on the form. Either thing needs to happen within 7 days of the date of the event. It needs to be postmarked within 7 days if you mail it, done online if you do it online. But you don't automatically lose your license. You have a right to fight about it. If you were good to drive before, you're still good to drive for at least 30 days after the event in most cases. Always check with a lawyer. but that's a very safe rule of thumb. So what is that myth? You automatically lose your license after DUI arrest? Not true. In fact, if you blow under the limit or the machine doesn't work, there's not going to be any administrative action at all. So check with the lawyers. Sometimes we still want you to request a hearing to be safe because sometimes we don't remember exactly what happened. But I want you to pay attention. That myth just isn't so. So myth number 3 sort of is the opposite of myth 1. Myth number 3 is you cannot be charged with a DUI if you're under the legal limit, 0.08. So many people say, hey, I'm under 08, I'm innocent, right? Absolutely not. That myth is false. There are 2 ways to be found guilty of DUI. One is per se, 0.08 or higher if we're an adult, and one is your ability to drive is affected by alcohol in any appreciable degree. That's the under the influence prong. So there's no breath test or the breath test is under the limit. The prosecutor can still try to say, look, the field tests were terrible, they were fumbling around, or the driving was terrible, or they were slurring their speech, or they were falling down drunk, and 0.07 was really high for them, and so they were still dangerous. Their ability to drive was affected at any appreciable degree. So it's not a literal defense to be under the limit. It just takes away the automatically guilty prong for the prosecutor, so the prosecutor has to do more. But if you've done field sobriety tests, if you've been sort of suckered into doing field sobriety tests, they're going to have plenty of evidence they may use to show that you're guilty in their mind. I've seen people charged with DUI for 0.02, 0.03, 0.04, 0.05, all the way up, of course, to 0.08. It doesn't necessarily mean you'll get convicted of DUI, but if there's alcohol in your system and they have a good reason to stop you, more often than not, they're eventually going to charge a DUI. So avoid making that mistake. If you get arrested and you're under the limit and the cop doesn't charge you right away, you still need a lawyer, okay? Because they're going to send it to the prosecutor and the prosecutor's going to charge something. If they don't charge DUI, they may charge negligent driving first degree, also a crime. What is negligent driving first degree? In layperson's terms, operating a motor vehicle in a manner that's not perfect, negligent, and showing the effects of consuming alcohol, but you're not drunk. So there's more details on that, but that's how you want to think about it. So if you're under the limit, don't fall for the myth you can't be charged. You probably will be. Myth number 4, a DUI will permanently ruin your life. Let me tell you, that's totally false. I spend so much of my time talking to people that feel so terrible, and as well we should if we made a mistake and endangered ourselves and others for driving under the influence. But it's not going to ruin your life, assuming that it's just a standard DUI. There's things we can learn from this, and what I typically say is from the driver's perspective, a first offense DUI is inconvenient and it's going to be troublesome, but typically speaking, it's not going to end your job, end your life, end your reputation. I mean, without getting into too deep in the weeds, because there's a lot of people that get upset when we talk about DUI, and rightfully so. DUI causes a lot of damage, and I'm totally against it. But realize that for the most part, there's a lot of physiology going on when we consume alcohol. Alcohol turns off that no center in our brain, and there's never an excuse. But people become less cautious when they're drinking, and a person who would normally never make such a mistake can end up making a mistake one time for lots of reasons. But for me, for doing this for 30 years, unless you have a very sensitive job, professional driver, commercial driver, someone who needs to travel to Canada, we are in Washington State, a DUI is inconvenient. It doesn't carry a lot of stigma with employers for normal jobs. And usually there is a way back from that type of charge. So if you're in that situation, realize that the myth that is going to ruin your life, that's what it feels like, but it's not what I've seen over 3 decades of doing this. And I think the final myth that I want to cover, myth number 5, is that every case is going to turn out the same just because of a certain fact pattern. That's not exactly so. A 1/6 breath test in one jurisdiction will not turn out the same as a 1/6 breath test in another jurisdiction. What really controls outcomes in cases is the culture of the court and the prosecution. That's prosecuting the offense, and also what it is that the defendant does after the fact to show that they're taking it seriously, right? Did you do an alcohol evaluation quickly? Did you follow up with any classes quickly, right? What is your prior record? That matters as far as what the outcome is. And so highly rated attorneys will get similar results, but you want to talk to an attorney about what's normal in the jurisdiction where this happened. And then you will have a better idea of, what to expect in the future. There's lots of things a defense attorney needs to do. We need to get evidence, we need to preserve evidence and all that. But sometimes we say, hey, well, my friend had this breath test level and this is what happened to them. That doesn't necessarily mean that's what's going to happen to you, because every case is very unique. And never, ever trust what I call lawyer Google. If you're not on YouTube, which is educational, and you're looking at like advertising materials of lawyers and stuff like that, the people that write those, it's their incentive to scare you, right? This worst case scenario. And, if we're a normal, good person, we're already so worried and we're so upset that we put ourselves in this situation that we're sort of, get worked up by anything. So, find a decent, friendly sounding, experienced lawyer who has knowledge about that particular county or city where the problem happened, and they'll be in a much better position to sort of let you know what to expect. So don't fall for the myth that every case is just the same. It is not. So I hope you found me covering these 5 myths useful. If so, please like and please subscribe. More people will get to hear this and get the help they need. More importantly, if you have a DUI or any other criminal situation, you can always give my office a call. We're in Linwood, Washington. We do most of Washington State. We've been doing this for more than 20 years on the defense side. We'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.